It is my pleasure to welcome you here on behalf of Dean Angela Onwuachi-Willig and to welcome you to the 2024 Kleh Distinguished Lecture in International Law. Today's lecture is made possible by William Kleh and Patricia Kleh. Bill is a graduate of BU's class of 1971, and years ago, he and his wife, Patty, made a generous gift to establish this lecture, the William and Patricia Kleh Distinguished Visiting Professorship in International Law, and to support this lecture series. Bill and Patty have joined us today. And we would like to extend a warm welcome to you both and to express our sincerest gratitude to you for your generous contributions. And for my part, international law is a critical subject for any aspiring or practicing attorney in the 21st century. We are living in an increasingly global society, and this accelerating trend towards globalization is certain to continue. Globalization is not simply about economics and trade and foreign investment or the global marketplace. It is also about environmental justice, it is about ethics, it is about human rights, and as we will learn from Professor Preeti Dash, as she will explore in her lecture, it is also about the transfer of politics in an interconnected world and how that transfer shapes and influences regional activism and criminal reforms. As Bill and Patty Kleh have long recognized, because of the impact that international law has on all of our lives, it is critical that we seek greater education about globalization and international law. So, even if an attorney plans to practice only or exclusively in the United States throughout their career, knowledge of international law is important to give a holistic understanding of the law and civic engagement in our global community. We are better attorneys when we appreciate the different ways different jurisdictions and bodies of law inform and influence how we live. They're influenced by one another, they inform one another, and some of the most important challenges of our life and time are interrelated and will impact everyone everywhere in some way, if not in the same way, when we think about climate crisis. Our increasing global interdependence is why the Kleh Lecture in International Law is so critically important, perhaps now more than ever. Since the lecture was first established, we have welcomed legal scholars from around the world to discuss tort litigation reform, state sponsors of terrorism, the legality of torture and enhanced interrogation methods, victims' rights, international criminal law, income inequality, citizenship, crimes against humanity, and many other important topics. We are extremely grateful to the Klehs for providing our students and our entire law school community with the opportunity to engage with esteemed scholars of international law from around the world on these topics, and today is no different. Okay. Today, we welcome Professor Preeti Dash from National Law School in India. This is one of the top universities in India. For those who don't know, it's the top law school. She is the 7th Kleh Distinguished Visiting Professor that we have had the honor of hosting here at BU Law. If you haven't had a chance to get to know her, I highly recommend that you do. She's wonderful. She's a legal academic, and her research focuses primarily on criminal law and policy. She's currently pursuing a PhD in law at the University of Cambridge, where she's a Gates Cambridge Scholar. Her recent work focuses on the downsides of punitive approaches to sexual violence in India. She researches the disparate impact of the criminal justice system on the marginalized, particularly focusing on the death penalty, sentencing laws, and sexual offenses. Professor Dash's work has been published in the Indian Law Review, the Indian Journal of Gender Studies, the National Law School of India Review, the National Journal of the University of Delhi's National Law Journal, and more. She's publishing also columns and opinion pieces on criminal law, sentencing, the death penalty, and sexual harassment. So she's a public intellectual as well as writing to our academic community. She served as an assistant professor at National Law School in India, in Bangalore, and she teaches criminal law, torts, property law, and leads seminars on violence against women. She also worked as a summer academic fellow at Harvard Law School, just over there, and a research scholar at Project 39A, National Law School, University Delhi, where she researched and published on capital sentencing in India. Prior to joining the Legal Academy and focusing on criminal law, she worked as an in-house counsel for a multinational telecommunications company. She holds her LLB with honors from National University Law School in Odisha, where she was the Dina Badusawu Memorial Gold Medalist. She holds an LLM from Harvard Law School under the Fulbright Nehru Master's Fellowship, a Master's of Science in Criminology from the University of Oxford, where she was an award-winning scholar, winning the Roger Hood Prize and the Routledge Prize for her outstanding performance and her dissertation in criminology. Please join me in welcoming this year's Kleh Visiting Professor of International Law, Professor Dash. I forgot to add that Professor Dash will speak for 35 minutes. We then will open the floor. I will be moderating questions from the floor. When you do ask your question, we're going to encourage you to stand up, or if you don't stand up, please state your name, affiliation, and your question. Thank you.
Thank you, Erika, for that extremely generous and embarrassing introduction. Thank you so much to Bill and Patty Kleh, who I met earlier today morning, for this very generous endowment and for having me here at BU. I've really enjoyed my time here. I think I was here in perhaps what is the best season in Boston. I'm also very grateful to everyone at Boston University School of Law, Dean Angela Onuachi-Willig, faculty colleagues who've been so warm and welcoming towards me, colleagues Zach Dubin, Emily Robichaud, Krista Woods, Elizabeth and Kim, who've made my transition process so smooth and made me feel like I'm home at BU. Thank you so much to all my students who show up every week to listen to me talk about very difficult topics in this very difficult political time. Thank you so much, everyone, for having me here today. So I'm going to talk about the carceral journeys of feminist activism, how feminist activism in the US influences activism around criminal law reform in other parts of the world and sometimes produces unintended consequences. So let me begin, and then gradually we can get into the linkages that I will talk about. So in March 2020, India executed these 4 men who were convicted of the gang rape and murder of a young woman in New Delhi. In what was projected across the political spectrum, barring a few left parties, this was considered to be a political victory for all Indian women, that these executions were being carried out in the name of protecting Indian women. This was also the first time in 16 years that India was carrying out death sentences for non-terror offenses. This incident, this crime, which took place in December 2012, changed India's criminal law landscape, making it more punitive in terms of responding to violence against women. So here on this slide, you see the victim's mother, Asha Devi, who engaged very actively in street protests across the country. Immediately after this incident, in response to mass protests in different parts of the country, the federal government constituted a judicial committee headed by Justice J.S. Verma, former Supreme Court judge, and asked them to suggest reforms to criminal law on sexual violence. Backed by feminists who participated very enthusiastically in the criminal law reform process, this committee suggested many reforms in criminal law and more broadly as well before the Indian Parliament, and eventually these suggestions found place in the Criminal Law Amendment Act of 2013. This act expanded the definition of rape to include non-penovaginal offenses as well as non-consensual oral sex, and also introduced a mandatory minimum punishment of 7 years for the offense of rape. Soon after this legislation was enacted, the federal government in India changed, and the Bharatiya Janata Party, the BJP, headed by Prime Minister Narendra Modi, came to power. Now, since this amendment, the Indian Parliament has twice revised the substantive, procedural, and evidentiary laws, criminal laws around violence against women, with the latest rounds of reform involving a complete overhaul of criminal legislation in the name of decolonization, but in fact making it more punitive and hierarchical. In 2015, in response to the incident, the Juvenile Justice Act was amended, which made juveniles, that is, people below 18 years of age, eligible to be tried as adults in cases of serious crimes like rape, particularly in cases of serious sexual offenses. Other brutal incidents of sexual violence, particularly gang rapes and stranger rapes that have captured public attention and newspaper headlines, at least 3 states have now introduced the death penalty for non homicidal rape of adult women. And even more shockingly, it has also led to public endorsement for extrajudicial killings of suspects in police custody. So, the picture that you see here is of women distributing sweets after the police killed 4 accused in the Hyderabad gang rape case. They were killed in police custody. Now, having said all of this, here I have some statistics which show how the judiciary has been responding to this trend of how sexual violence, which comprised around 16% of the total death sentences that were given out in the country in 2016, that proportion has been increasing and now is anywhere between 30 to 50%. So, of the total number of death sentences that are given in 2016, we saw that around 16% were for sexual offenses, but now it's more than 50%. So, the punitive trend towards sexual violence, towards how the state responds to sexual violence, really lies at the heart of the debate on criminal justice system in India today. But having said all of this, you might be wondering, why is this relevant for an audience sitting in the US? Well, because rape laws in India, anti-rape laws as they stand today, are a product of feminist activism over decades. And Indian anti-rape activism, particularly the kind that has been led by the mainstream feminist groups in India, has been very deeply influenced by American dominant feminist thought. Now, before I start, I want to clarify that there are 2 things that I'm not arguing. I'm not arguing that everything that is wrong with criminal law enforcement in India today is the product of American feminist thinking. My limited argument is that as American feminist thought, particularly dominance feminist thought, travels to different parts of the world, it influences feminist activism there and produces unintended consequences, overshadowing the more marginalized forms of feminist resistance that come from socioeconomic groups in India, such as the Dalits, or the religious minorities, such as Muslims. Moreover, as radical feminist ideas interact with legal systems in very conservative patriarchal settings, they are not received very well and they produce consequences that are perverse in ways which are very different from how the hypercarceral problems that confront the US society today. The second thing that I'm not arguing is that Indian feminists have uncritically imported feminist ideas from the West. In fact, the long and arduous journey of feminist struggles in India has been very resistant to imperialist tendencies in Western feminist thought, and they have been very deeply critical of the state and also reflexive around major sociopolitical issues, such as the co-option of Muslim women's concerns by the Hindu right wing. Having said this, however, in the limited aspect of rape law reform, Indian feminist thinking and American dominance feminist thought see many parallels. Now, so when I say American dominance feminist thought, I'm primarily referring to the school of thinking by scholars and theorists such as Catherine MacKinnon and Andrea Dworkin, who build their theory around structural subordination by men of women, the linchpin of which lies in sexuality. So, as Catherine MacKinnon has famously quoted, that if sexuality is central to women's definition and forced sex is central to sexuality, then rape is indigenous and not exceptional to women's social condition. Subsequently, as MacKinnon turned to legal activism, this theory of structural subordination based on sexuality is reflected in her writing and as well as her activism around sex work, around pornography, and sex discrimination through sexual harassment. Now, this school of structural subordination theory has been widely absorbed by liberal legal frameworks across the world, and feminists have made use of this theory of structural subordination to expose how legal systems across the world invisibilize violence against women. This has been true not only in the Anglo American world, but other jurisdictions in the global south, as well as in international criminal law. And the case is not very different for Indian feminist activists, particularly as they turn to criminal law, seeking to reform the state's responses to violence against women, to domestic violence, and to sexual assault. Now, when I say mainstream feminist activism, I primarily mean the Indian women's movement, which was an autonomous movement that sprung up in the 1970s, breaking away from left political parties, disillusioned by their neglect of women's issues. Over the years, the character of this autonomous movement has changed, and in the early 90s, as India opened up its economy to liberal and globalization policies, these groups took on the form of a funded NGO. Today, this funded NGO model is under attack as the Bharatiya Janata Party, led by Narendra Modi, attempts to cancel their licenses to receive foreign funding. So that is the state of mainstream feminist activism in India today. Now, my argument is that parallels between Anglo-American dominance feminist thought and the Indian women's movement's anti-rape activism can be drawn primarily on three counts. Firstly, rape continues to be conceptualized and understood within Indian feminist thinking as a gendered crime, perpetrated only against women by men. Rape of men and rape of trans persons is not criminalized under the provision for rape in Indian criminal law. So if you look at Section 375 of the Indian Penal Code, only a man can commit rape of a woman. To their credit, for mainstream feminist activists post-2013, as they engaged with the Verma Committee, they were more open to making rape gender neutral as far as the victim was concerned, but not for the perpetrator. This reinforces what Catherine MacKinnon had famously said, that to be rapeable is to be a woman. The second, besides this gendered understanding of the offense of rape, the two more serious aspects where parallels can be drawn between these two categories of feminist activism is firstly the understanding of a universality of sisterhood that seems to bind all women together. Now, like I said, the Indian women's movement sprung up in the 1970s, breaking away from left political parties. This autonomous movement turned to rape law activism in the 1980s, prompted by some serious cases of rape that were committed in police custody against women from marginalized groups, Dalits, indigenous tribes, and Muslims by police officers. So, using these incidents, the IWM activists, the women's movement activists, they critiqued state power, and they said that state power was exemplified by the rapes that were committed with impunity by police officers. Simultaneously, they also critiqued left-leaning political groups for being silent about rapes and other forms of violence that were committed by working-class women. In other words, they argued that violence was experienced by all women, cutting across caste, class, and religious lines, and stemming from patriarchal domination. In other words, a universality of sisterhood was built into this articulation. And it is in such an articulation that the parallels between Anglo-American dominance feminism and the Indian movement's anti-rape activism becomes prominent. Now, Anglo-American dominance feminism has been critiqued very deeply by feminists who come from the intersectionality or the post-colonial traditions who reject this conception of women as a homogeneous category. To their credit, in India, the women's movement was cognizant of the power differential that existed between different groups, between different social groups, along lines of caste, along lines of religion. What they did not articulate, however, was the power differential between different groups of women and how some women exerted power in the society, drawing from their dominant caste or religious identity. This started becoming a problem when women from dominant communities became visible publicly, not as victims, but as perpetrators of violence. So in 1992, in the Mumbai anti Muslim riots, many Hindu women participated in anti Muslim violence as perpetrators, fracturing this understanding of the universality of women's experience only as victims. In different parts of the country, where men from oppressed castes were being hacked to death by others from dominant caste groups for their alleged indecent behavior towards upper caste women, the women from these dominant communities were not only inciting the men, but were participating in the violence. In one of the most shocking cases that came in 2006 from Khairlanji in Maharashtra, an entire Dalit family was killed by members of a dominant caste from a neighboring village. And eyewitnesses testified that women from this oppressor caste mob first entered the household, the house of these people of the Dalit family, dragged the mother and the daughter, Surekha and Priyanka Bhotmange, by their hair, dragged them out of their huts, beat them, and then stripped them. Both these women were later handed over to male members of the mob who gang raped and murdered them. This was one of the most shocking incidents that did grab newspaper headlines, and feminist groups actively mobilized against this as a form of anti caste violence. However, what they did not articulate was that there was a reality that they were unwilling to confront, that some women exerted power in the society, deriving this power from their dominant caste or religious identity, and using this to subjugate vulnerable women as well as men from oppressed communities. This was not something that reflected in the women's movement's anti-rape activism, which was premised on the universality of all women's experiences. This is a comic strip around anti-caste violence that talks about how many mainstream feminist activists who talk about the Delhi gang rape case or similar other gang rapes in the recent past don't even know about what happened in Khairlanji and how women were part of that mob that eventually killed the family. The third category, where parallels between Indian anti-rape activism and American dominance feminism can be drawn, is in the understanding of aggravated rape. Now, aggravated rape under Indian criminal law is rape committed by someone who has authority or custody over the victim, and it is considered more serious than rape simpliciter. The punishment for aggravated rape is higher, and there is a reversal of burden of proof in certain cases. And all of this came from feminist groups who mobilized around rape law reforms in the early 1980s, prompted by the rapes that were committed by police officers. Now, as this became a prominent part of criminal law in India, feminist groups, when they participated in the Varma Committee consultations, tried to broaden the category of aggravated rape. And in their submissions to the Varma Committee, the reinforcement of male domination and female subordination was stark. By the time the Criminal Law Amendment Act of 2013 was enacted, this category had been expanded to include all rapes committed by men in a position of dominance over the victim. So if you look at point K on the slide here, it refers to any offense where a man is in a position of control or dominance over a woman. In addition, what the women's movement tried to do was to bring within this category the rapes that were committed against women from more vulnerable social groups. So they cited examples of Muslim women who were raped during the 2002 Gujarat riots. On the slide here is Bilkis Bano, who was raped in 2002 in Gujarat, and 16 members of her family were killed in that same incident by a Hindu mob at a time when Narendra Modi was the chief minister of the state. So women's groups cited these examples and said that they wanted rapes of those categories to be included within the provision for aggravated rape. However, when the law was eventually enacted, it did not define aggravated rape as that committed by men from dominant groups and did not even acknowledge the particularities of identity of either the victim or the perpetrator. So if you look at point G in the slide, it includes rape that is committed during communal or sectarian violence. Under this provision, even men from marginalized groups could be charged with aggravated rape, and it does not protect only women who belong to a vulnerable social group. However, this provision did not receive any feminist backlash and, in fact, was enacted with the help of feminists who proactively made suggestions before the Verma Committee. Now, these internal theoretical inconsistencies between feminist positions in India re emphasize that universality of sisterhood and understanding of women's experiences only as victims foregrounds the women's movement understanding of rape. Moreover, while the Indian feminist activists have been cognizant of existing power differential between different caste and religious groups, in the limited context of rape law reform, they have been tolerant of the law's under recognition of these realities. Arguably now, some of these issues stem not from feminist activism, but rather from the process of translating feminism into criminal law. The reduction of rich feminist debates into a flattened account of law speaks to the limitations of criminal law itself, which may reduce transformative projects into a mere set of legal rights or wrongs. What remains thus is a formulaic expression in the black letter of the law, which primarily reflects a dominant feminist framework premised on an understanding of the universality of women's experiences only as victims. And that brings me to the next part of my lecture. If mainstream Indian feminist activism around rape law in India theoretically draws from dominant feminism in the US, then how do critiques of the latter apply to the former? And here I particularly refer to the critique of carceral feminism, which is a term that was coined by sociologist Elizabeth Bernstein to explain dominant feminist frameworks around criminalization of sex work and trafficking and the perverse consequences that it produces on victims from marginalized groups. She discusses how it even leads to the deportation of migrant sex workers to life-threatening conditions in their home countries in the name of protecting the American family. While critiques of carceral feminism have been most prominent in the US, they have also started to emerge in other parts of the world. In Fiji, for instance, Kokonasiga argues that the feminist-backed Domestic Violence Act of 2009 operates primarily within a network of colonial laws and ignores the colonial experiences of indigenous women. In Ecuador, Tapia Tapia has found that feminist support for human rights interventions helped expand criminal legislation for domestic violence and in the process took all the attention away from civil dispute resolution mechanisms which provided women with financial assistance, with housing, childcare benefits, and social services, elements that are entirely missing from criminal law responses. In India, as I have explained, the Indian women's movement has been historically critical of the state and has been resistant to giving unbridled power to the state. Scholars such as Flavia Agnes have questioned why feminists invest so much time in India around law reform when decades of criminal legislation in India has shown that the experiences of victims are not really improving despite those changes. Yet, the Indian women's movement has not given up on its project of legal reform, and in fact, this intensified in the aftermath of the Delhi gang rape case because there was a lot of public mobilization around the issue. So when the Verma Committee became amenable to suggestions from the public, feminist groups participated very enthusiastically in this process and gave a lot of suggestions. At the core of feminist demand for rape law reform lay the need to recognize that harm against women was committed on a graded continuum of violence, scaling from low to high based on the degree of harm and humiliation. So they unanimously suggested that the definition of rape must be expanded to include non-penovaginal intercourse as well as forced oral sex. So the definition of rape in Indian criminal law, everything that you see in red here was introduced after the Criminal Law Amendment Act of 2013. Prior to that, rape law was only defined as non-consensual, forceful, penovaginal intercourse. On the question of punishment, feminists demanded the removal of judicial discretion and the introduction of a mandatory minimum punishment of 7 years of imprisonment. So, Section 376 introduced a mandatory minimum of 7 years of imprisonment. And although they outrightly rejected the death penalty, citing how it gave unbridled state power, they also endorsed life imprisonment without any form of remission or parole in cases of aggravated rape. So they were functioning very much within a carceral framework. And in some cases, they were willing to completely abdicate penal theories around reformation and rehabilitation. So, given this backdrop, I analyzed the applicability of the critique of carceral feminism to Indian anti rape activism by studying rape adjudication in Delhi. So, I looked at 1635 rape judgments that were pronounced by trial courts of Delhi between 2013 and 2018. And this time period is significant because it allowed me to look at cases that were being decided under the older law as well as the new law of 2013. As I'm speaking to you today, 2013 Amendment Act is no longer the new law. The latest law was brought in 2024, and the mandatory minimum has been increased to 10 years of imprisonment in cases of rape simpliciter. But as I was studying these judgments, I was looking for two things. I was primarily trying to understand how feminist demands for punishment had translated into practices in law enforcement and adjudication. I was looking at the rates of conviction for these offenses and the nature of cases that were being decided under both these laws. What I found had parallels with what critiques of carceral feminism have said in other jurisdictions, that hypercarceral measures have perverse consequences not only on perpetrators but also on victims. So, in my research on conviction rates, what I found was that under the old laws, in fact, the conviction rates were higher. Of the 726 cases that were adjudicated under the old law, 16.11% resulted in convictions, and of the 909 cases that were adjudicated under the new law of 2013, only 5.72% resulted in convictions. Now, I do not endorse the view that higher convictions necessarily mean better outcomes for victims. But it cannot be overlooked that this was one of the main demands of feminist groups who participated in the Verma Committee consultations. So they spoke about the abysmal rate of conviction for crimes against women and how it was lower than conviction rates in other crimes. So how does it happen that after a supposedly feminist law reform project, the rates of conviction fall even further? I think there are parallels to be drawn here between what was being discussed here at BU School of Law over the weekend in the Law Review Symposium around law and expertise. While feminists were enthusiastically participating in this law reform process, thinking that they are the experts on sexual violence, they were willing to ignore this vast body of critical criminal law and sentencing literature, which has shown across different jurisdictions that mandatory minimum laws almost always lead to higher acquittals, that judges are not willing to convict in cases that they feel are not serious enough to warrant such high terms of imprisonment. And in the case of India, that is particularly true because judges are functioning within a very conservative and patriarchal setting. So, how do we expect judges who earlier gave 2 years or 3 years of imprisonment in cases of rape, citing reasons such as the sexual history of a woman or other rape myths, to now be giving 7 years or even 10 years more recently for cases that they feel are not serious enough? So, juxtaposing this broadened definition of rape with a mandatory minimum sentencing process, it actually ended up reducing the conviction rates. And of course, there are a lot of other factors that influence these outcomes, but that was one of the major changes that took place at that point of time. My other finding was in terms of the nature of cases that were being adjudicated before the trial courts of Delhi. I found that under both laws, nearly somewhere between 20 to 30% of cases belonged each to the category of breach of promise to marry cases, where women bring charges of rape against their partners with whom they've had consensual sex when the men refuse to marry them, and love affairs or runaway marriages, where the parents of a woman bring charges of kidnapping and rape against a man when their daughter decides to marry outside the caste endogamy framework. So these two types of cases continue to dominate rape adjudication uh, prior to the 2013 law as well as after it, and they have very high acquittal rates, as in most cases, the victims turn hostile. My findings also resonate with those of other studies. The National Crime Records Bureau in India has found that in 93% of registered rape cases, the offender was known to the survivor. And empirical research by journalists such as Rukmini Srinivasan and scholars such as Arushi Garg at the University of Cambridge, they show that anywhere up to a third of rape cases deal with consensual sex. And of the cases of non consensual sex, a majority of the accused are known to the victims. Yet, marital rape is not recognized as a crime in India. So, from a feminist perspective of enhancing sexual autonomy, there appears to be a crisis where egregious cases of stranger rape and gang rape are driving criminal law reform. But this is working to the detriment of consensual sexual arrangements. Even claiming that breach of promise to marry cases should be criminalized, whether as rape or otherwise, is a rebuttable feminist claim at best, where you seek to reinforce marriage as the sole legitimate site of any form of sexual expression. So, in the limited context of rape law making, the critique of carceral feminism can be extended to mainstream anti rape feminist activism in India. And I say this with full caution that feminist groups in India are not a monolith, and they continue their critique of the state, which has become increasingly right wing, misogynistic, and relies on criminal law to curb sexual autonomy of women. However, the problem arises when there is very little conversation around the normative role for carceral punishment for sexual offenses within feminist circles. The focus of the Indian women's movement has been to visibilize violence against women using tools of criminal law. And that becomes a problem when state authorities respond to populist demands by enacting harsh punishments for sexual offenses. Feminist groups then are unable to contribute to the discourse beyond denouncing the developments. And this makes it necessary for feminist groups to anticipate how they are going to reimagine their relationship with the state, and foregrounds the understanding that strategic feminist advocacy should not mean merely turning to criminal law to address all social problems. Thank you so much.
Thank you very much. And now, wow, okay, so I see 1, 2, 3, 4. I'll just start going from that side of the room to the other. Jess.
Hi, Jessica Sylvie, and of course, we're neighbors in the suite. Thank you for a wonderful, wonderful talk. Super provocative. I actually, sorry. Yes, Jessica Sylvie, faculty member here. Preeti and I are sweet neighbors. Thank you for a wonderful talk. My question, really informative rather than critical of your. I wanted to know more. You kept talking about judges, not juries. I just don't know, are juries involved in any of these acquittals? And how does that work in terms of popular legal consciousness as opposed to what's going on in the courtroom? And then what, in your mind, prevents the rape laws from being changed to be gender neutral?
The first question, we don't have a jury system. All trials are presided over by judges who are trained in the law and at the trial court level. And then there are appeals which go to the high court. So every state has its own high court. And from the high court, you can appeal, like criminal appeals go before the Supreme Court of India. So there's no jury. And in popular discourse, particularly in tabloid media, there is a lot of conversation now about how judges who claim to be experts want to uphold rule of law and let rapists go away. And by getting away, they mean something like 14 years imprisonment or 20 years imprisonment and not the death penalty. So it's a very carceral push that is driven by the media and now also by the government. Um, what prevents rape law from being gender neutral? Well, feminist activists have historically influenced rape law reform in India since the 1980s. And their argument is that if it is made gender neutral, then nothing would prevent men from bringing these charges against women. And in a patriarchal, conservative country like India, we just cannot afford that. So it's a social argument which seems to find acceptance in the legislature. And from men's rights groups, that is seen as a threat. They feel that all laws favor women, including domestic violence legislation. Only men can be criminalized for it. So that kind of gives fodder to their arguments as well. But it is a social argument.
Hi, Preeti. I think we met before. My name is Steve Coe. I'm Associate Professor of Law here. First of all, this was really a fantastic talk and just so interesting on so many levels. So these are also informative questions. I guess I'm also wondering, kind of structurally within India, to what degree is there a federalism story to this picture? So everything that you've shown is the Indian Penal Code, which I take to be the equivalent of, federal law. And we know in the United States, for example, our conversations around abortion or other things, that there's a certain sort of coalition building that's required in order to mobilize for federal law changes as opposed to state law. So I was wondering how that was playing out in this particular case, especially if some of the coalition building is around women of certain castes. Maybe they have more access to the federal levers of power than others. And the second question, which is more theoretical, is I was wondering to what degree the story that you're telling here is rooted on the kind of ideal level of Marxist thought as kind of driving all of this. So this might be an impossible question to answer, but obviously Marxist thought is rooted in, Hegel's theory of history. Marx converts that into historical materialism, and there's a transnational solidarity that emerges around Marxist thought. Yeah. And McKinnon was also, as you probably know, was also very involved in the International Criminal Court, saying there's a universality to the story here. So is there something at the ideal level here that really drove so much of this? I was just wondering if you could play that out a little bit more.
Yeah, so thank you for those questions, Steve. Now, criminal law in India is federal, and states can introduce certain amendments, but in most cases they don't. So all trials that happen across the country are decided under the Indian Penal Code. In the initial part of the lecture, I mentioned how some states have now started introducing the death penalty for non-homicidal rape of adult women. And these are state amendments that are made to the Indian Penal Code, but that's highly unusual. It's only something that we've seen in the last 3 or 4 years. And that's because, states in India don't have that kind of liberty. They don't change criminal laws around different things to the extent that they do in the US. States don't have that kind of independence, and all trials take place under the Indian Penal Code. Sometimes there are some state amendments, and in those cases, for example, now in the state of Telangana, where also the extrajudicial killings started taking place, when a non-homicidal rape of an adult woman takes place, the defendant can be given the death penalty, but that's not true for the trials that take place in other states. But primarily, all of this is being adjudicated under the Indian Penal Code. Regarding the second question, yes, I have been thinking about this. But I think what complicates the picture is that these women's groups, they actually broke away from Marxist, Leninist political parties. And they were saying that for these left-leaning political parties, they are also willing to be silent on issues that concern women. I think there's a parallel to be drawn here between the very early years of feminist activism in the US, like shelter homes, like people like Shulamit Firestone, and how they emerged from this left tradition, but also looked inwards to critique how theories like Marxism have been ignoring women's issues for the longest time. But yes, in more recent years, Marxist feminists have started talking about how neoliberal economic policies, which drive this kind of extreme inequality in big Indian cities where working class men are primarily living in terrible conditions and are constantly being exposed to the things that they cannot have, the and they have absolutely no interaction, no healthy interaction with women, how those kinds of arguments are not featuring at all in mainstream feminist activism. But these groups, the autonomous groups that emerged in the 1970s, they're also very critical of left-leaning political groups. So that kind of complicates the picture a little more. Yeah.
Hi, Preeti. This is
Hi,
a
Zora.
fabulous presentation. Zora Ahmad, I teach here. So I just had a comment and then a question about, I think it sort of builds on Steve's point about the universality. So it seems like what I feel like is a really important contribution about your piece is that carceral logics are always exclusionary and that they will tend to magnify, if not expose, disproportionalities, inequalities, asymmetries. And so that's the critique I think that abolitionist feminists have made within the United States. And so it's interesting to see that kind of same dynamic appear in India. And so I think that's just a really valuable contribution. And then I think sort of as a question, I'm wondering sort of how, Angela Davis went to India and had a really great conversation with Gail Omvet about kind of the relationship between race and caste and to what extent you can transport similar critiques across these two different societies. And I'm wondering whether that's, to what extent that conversation is happening within feminist circles who are reflecting on maybe the inadvertent consequences of carceral policy. And then I think also I'm just, within the United States, radical feminists and abolitionist feminists are looking outside the United States for models for mitigating, addressing social harm that are really grounded in other communities where there are sort of indigenous practices of outside of courts. And I'm wondering whether you've studied sort of that transfusion the other direction, not just from the United States to India, but India back to the United States.
Thanks, Zora. Those, very incisive points. And this is something that I have been thinking about, like how does transfer happen in the other direction? I think what has made the situation very volatile in India is that the political power has completely shifted and moved rightward. So with Modi coming to power in 2014, these feminist groups who were earlier welcomed into the lawmaking and policy making spaces, even the mainstream feminist groups, they have been kind of pushed to the corners. They are the marginal voices now. And the right wing in India has been trying to make use of the Dalit or the anti-caste groups to consolidate a Hindu vote base, saying that, we have to remain united because otherwise the dangerous other, which is almost always the Muslim, is going to attack us. And for feminist groups across these different categories, like be it Muslim feminists or Dalit feminists or even the mainstream feminists, they have been trying to build a kind of solidarity that is anti-state, anti-BJP, and that's also kind of pushing all of them towards a centrist kind of politics, where they see only the Indian Congress Party, which is the grand old party, as the only viable political solution. Now, in the process, what is happening is that a lot of radical elements within anti-caste feminist activism or Muslim women's activism, that is kind of being tamed. This is something that Prabha Koteswaran also talks about when she says that when these autonomous groups began to emerge, they were seen as radical. They were seen as groups that would take on the structure of the Indian state. But gradually they have been diluting their oppositional stand towards the state. So in that light, with what is happening around anti-rape activism in India, I think it is much less radical than what you see happening in the abolitionist spaces in the US. And perhaps the reason also could be that for many marginal groups, their demands have been that the criminal law process should be equally applicable to them when they are victimized. So they say that it's a problem if the death penalty is given out only in cases of like the Delhi gang rape case, where the victim was a middle class educated student, and not in the Khairlanji case, because they feel that the state is absent when it comes to protecting their rights. So I don't know if I've answered your question, but the nature of the activism that's happening even in the marginal spaces today in India, post Modi, that's very different. So maybe that's why that conversation is not happening. But having said that, there are very few groups that, like critical criminal law groups actually, like criminal defendants, public defenders, who are getting together and trying to increase the practice of restorative justice or transformative justice in some cases of sexual abuse of children, where the perpetrators are the family members, in a way that does not have to necessarily go back to the police or the criminal legal system. So maybe that form of activism is something that we could look at.
Thank you so much. My name is Aziza. I also teach here. We're office neighbors also. I just thank you so much for this work. It's so amazing. And I think also so brave, you know, really what you're doing, the critical posture you're taking towards Modi and the sort of mainstream feminist movements. And part of the thing I wanted to hear about is, you know, how when encountering this mode of critique, feminists engage, you know, do they not engage? Is there sort of such a deep belief in this sort of universal, the possibility of a universal application of the criminal code that they think, oh no, like this is a process we have to go through to sort of legitimize the claims that are being made by women who are experiencing sexual assault. The other thing I wanted to ask about was, you know, just continuing along what you started answering earlier with regard to Modi, you know, like it's so unbelievably fascist to imagine that you can just extrajudicially kill people who are accused of I mean, and of course that's going to take like it's going to play out on caste and religious lines. And I feel like there's like something deeper that's being activated that is, I mean, the Modi government is extraordinarily violent, you know, like he won partly because he engaged in a pogrom in Gujarat in 2002. And so it's like a continuation of a particular type of violence that seems to be sort of, that people are embracing, or at least at this, I mean, that was a very small example, so I don't want to make too much of it, you know, that you're giving, you know, sweets to the police officers or whatever. That could have just been that neighborhood. But the third thing I just wanted to ask about was Me Too, because, you know, one of the things I've found the Me Too politics in India really fascinating. And and just to say also, I was in India after the Nirbhaya case, and I saw the billboards that the feminists had put up with like the handcuffs and stuff. But on the Me Too movement, I felt like there was and I could be totally wrong about this because this is like me reading the Indian blogosphere or whatever, but I got this sense that Dalit politics were mobilized in a different way around Me Too. Like it was almost an embrace of the carcerality as opposed to the way you talked about it, which is that the Dalit politics were sort of, or Dalit organizers have been sort of more willing to take an anti-carceral position. And here in Me Too, it was more sort of, we need to make Me Too work for us and hold these powerful men in these universities. For example, professors were really sort of the focus there in some of those cases. And I wonder if Me Too was different because of the way it was framed as sort of happening in institutions as opposed to happening in homes and on the street, you know, because like maybe it was people thought, oh, I'm Dalit and this offers me a possibility of holding someone accountable at a university or at work, as opposed to like understanding that if the police are empowered, they're going to come into my home and potentially kill my family, you know. So I'm just curious, is that right? It could be totally wrong.
No. Thank you, Aziza. Like all very relevant questions and things I wish I had the time to touch upon in my presentation as well. So with regards to your first question, how do the mainstream feminist activists respond to this kind of research? They don't respond very well. And that's primarily because of the political moment in which we are in India today, although I don't know what it would have looked like prior to the Modi years. So the argument very much is that how can you be critiquing these positions that we took that expand the rights of women? So it's a very rights-based liberal approach where they say that how can you critique that when you know that politically we are the outsiders? We have been kind of elbowed out of the process entirely. So they are very critical of this kind of work. And even towards like Muslim feminist groups like the Bebak Collective, which are critical of criminalization of the triple talaq, which is like instantaneous triple divorce in India. It was recently criminalized. They say that, well, that is the only way that you engage with the state. There is no other way, that the law has a symbolic role to perform, and that is what we are trying to do. So they are not very receptive to these kinds of critiques, although to their credit, they are extremely critical of the Modi government and everything that they have been doing. So many feminist lawyers and activists like Vrinda Grover, Flavia Agnes, who are very mainstream, they also take up cases of people who have been killed in riots, or like, women who have been raped, like Bilkis Bano. She was represented by feminist lawyers at the Supreme Court. So they do take on the state, but they are not very open to a critique on their liberal position around criminal law reforms. Regarding the Modi government being very violent and perhaps being elected because of it, I think you're right there that very successfully they've been able to create this narrative of Indian Muslims as somehow the outsiders, equally, if not worse, than the British colonists who came to India, trying to say that Muslims are outsiders, the Taj Mahal should be a Hindu temple, and many ridiculous things. But like, as it has happened over 2 decades now, there is seemingly an acceptance of this, and simultaneously there is also an acceptance that in public, in popular media, if not elsewhere, that feminism is a Western idea, and NGOs are working on an anti-national agenda. So that these are not things that we should be supporting if we are nationalist enough. With regards to Me Too, yes, there was a particular incident where many Dalit women started releasing this public list of senior professors at universities in Delhi and in other major cities of male professors from upper caste communities, um, saying that these are people who are predators and they have harassed us. And immediately in response to that, the mainstream feminist activists, they put out a letter saying, you can't do this, we need due process. You can't release an anonymous list which names, like anonymous in terms of the victims, but putting out names of very senior professors and destroying their careers. And that is when the Dalit feminists and the mainstream upper caste feminists kind of got against each other, where the Dalit feminists were saying that, you've never supported us when it comes to our issues, and now we are going to do as we please. But where I feel that was a little different was that they were not embracing the carceral state as much as they were kind of saying that the social media is now an equalizer. So we are going to release these names in social media and see what the university does about it. So they were not kind of roping in the state. They were not insisting on registering police complaints or getting these people tried in courts, but just circulating all of this on social media.
Hi, my name is Amari Bruno Figueroa. I'm a 1L here. Thank you so much for such an incredible and insightful talk. It seems as though there are a good number of social and ideological assumptions that go into the feminist movement, particularly in legal feminist spaces that kind of reinforce dynamics of power, and using punitive measures to kind of reinforce power over generally marginalized perpetrators of harm. And as a law student, I think it is very discouraging, and I think
Sorry.
and so I guess my question for you is there any way for us to engage in legal advocacy that kind of bridges the gaps between philosophical understanding of more holistic and substantial resources for survivors that goes past punitive damages? Is there any way to bridge that gap that assists survivors now and actually brings about justice now, and that also kind of leads us towards a forward-looking understanding of restructuring how we understand holistic feminism?
Yeah, I mean, I don't have a full answer, but I think like what I was saying in response to Zora's question, that, some groups have been taking on some of these practices like restorative justice, like transformative justice, where they're actually speaking to victims, asking them what they want, and then trying to see how much of that can be provided either within the legal space or outside it. So maybe that could be an answer. Looking for creative solutions outside the carceral state, outside criminal law frameworks, perhaps that could be one thing. Now, just one example that comes to mind is that of rape crisis centers. In different parts of the world, but particularly in India, which were set up after this Delhi gang rape case. So the law was reformed, it was made more punitive, but these rape crisis centers were set up in different parts of the country. And a recent study that was undertaken found that they are understaffed. I mean, they're unstaffed. There is no counselor who sits in these rape crisis centers. And this is in a trial court in Delhi, which is the national capital. So one can imagine what it's like in other parts of the country. So when these reformist activities happen within the legal space, the problem is that the attention is always given to the punitive reforms, so to punishment, to see, how many trials are happening, how many cases are being registered. But in the process, the victim completely gets forgotten. And even psychosocial support or victim compensation, these are schemes that are part of legal systems, but they don't receive that kind of attention. And as I have been teaching some of my students, they talk about, who worked in rape crisis centers, they talk about these calls that they receive from victims who say that I don't want to approach the legal system, I don't think I'll be believed anyway, but I want to know where can I receive some medical care, where can I receive counseling, what are these things that I can do. So really, the needs of the victim seem to be aligned more towards looking for facilities, looking for services that help them heal, and the criminal legal system is really not doing that. So maybe thinking outside the legal system is one way to.
Well, that is a wonderful note to end on. I was struck by your slide, punishment is not accountability, accountability is not
There's
justice.
actually a group called Alternative Justice in
But
India.
it goes to asking what is it that access to remedy looks like for people who need justice. So extraordinary talk, and really pointing to the empirics of convictions going down, though the law reforms are what we said we feminists wanted, but maybe there's more that is needed. So this last question about how we think creatively about where law uses can occur to actually repair and restore was extraordinary. I also want to thank the Klehes for their extraordinary generosity. Thank you very much for being here with us today. Thank you for making this possible. And yes, and Bill saying I should thank our speaker. So thank you, Professor Dash.
Thank you so much. Thank you.